The International Criminal Court is now in session.
Good afternoon, everyone. I first would like to introduce the bench to you. On my right is Judge Kremer, and on my left is Judge Silva, and I'm Judge Hyeyoung Lee. Now I'd like to ask the parties for the appearances. Please briefly introduce yourself and how you wish to allocate your pleading time. We start with the prosecution and then defense.
Good afternoon, Madam President, Your Honors. My name is Merve Metin. I will be pleading on behalf of the Office of the Prosecutor for 13 minutes, and my co-counsel, Ms. Karsu, will be pleading for 12 minutes.
Good afternoon.
Please proceed.
Sorry, Madam President. Good afternoon, Madam President, Your Honors, and may it please the Court. I am Fehmi Levent Özkan, and I'll be pleading for 25 minutes in the name of the defense, and I reserve 5 minutes for my rebuttals.
Thank you very much. Yes, and I'd like to ask the prosecution with presenting your submission. Counsel for the prosecution, the floor is now yours.
Thank you, Madam President. Madam President, Your Honors, may it please the Court. My name is Merve Metin, and I'll be pleading on behalf of the OTP for 13 minutes. Today's case involves over 30,000 Earthbowers that were the victims of the crime against humanity of enslavement. There's a reason for that name. These crimes are an affront to humanity. Over the years, the Earthbower population in Fire Republic was systematically stripped of its fundamental human rights of practicing their culture and religion freely. They were then wrongfully ripped from their homes and enslaved by the very government that had been oppressing them for years, by the very government that was supposed to protect them. These victims will not unlive the terrors they have been through, but they can be granted justice. The only ones that can grant them any remedy are the prosecution and this court. As the collective servants and enforcers of criminal justice, we must do our best to get retribution for the victims. We will prove that there are reasonable grounds to proceed with the case at this stage in 4 issues. I will plead on the first issue that this court has subject matter jurisdiction over this case as it involves the crime against humanity of enslavement. And on the second issue, that the amnesty granted to Mr. Blaze does not affect the admissibility of this case. My co-counsel, Ms. Karsu, will plead on the third and fourth issues. I will move on to the first issue of jurisdiction. The acts at hand constitute the crime against humanity of enslavement and therefore fall within the jurisdiction of this court under Article 5 of the Rome Statute. There was a widespread and systematic attack directed against a civilian population, forming the contextual elements of the crime under Article 7. The attack in question does not need to be a military one. A campaign or operation carried out against a civilian population would constitute it. According to the elements of crimes and customary international law, the specific acts of enslavement include contemporary forms of slavery, which means right of ownership is not required, and the exercise of control over a person is sufficient. And these can manifest themselves as forced labor, cruel treatment and abuse, and force and coercion. The prisoners were detained in a facility surrounded by water with no means of escape. They were forced to build and repair cars, and if they refused to do so, or if they were too weak to do so, they were forced to stand outside in the snow in front of a picture of Lord Blaze with no food or water. Nothing about the detestable treatment of the prisoners was voluntary. There was enslavement. And this information comes from Mr. Rock's interview with JHR, an international NGO, which is admissible evidence according to the Rules of Procedure and Evidence, Article 104(2). The targets of these attacks were priests and regular members of the community, entire families of them. This constitutes a civilian population under the Geneva Conventions. An attack is widespread when it is of a large-scale nature and targets enough persons. At least 30,000 Earthbowers were direct victims of these attacks, clearly marking them as widespread. Alternatively, an attack is systematic when there is an organized nature of acts of violence and the improbability of their random occurrence. The systematic nature of an attack is in parallel with another contextual element, the existence of a state or organizational policy to commit them. According to the decision on the confirmation of charges in the Bagbo case, the existence of planning, organization, or direction by the state or organization demonstrates that there is such a policy. Over the course of 6 days, Mr. Blaise, with his executive order, tasked the BNS and Misazila with establishing peace. 40 centers were opened, education programs were developed, and implemented enough to be deemed successful. It is hardly possible that this course of action could have been actualized in this short amount of time without the planning and direction of the state, and therefore a policy to commit these attacks. And thusly, the attacks were committed in a systematic and pre-planned fashion in accordance with the policy. Further, the arrests of 40,000 earthbowers were made between 12th and 14th of December. Exhibit 1 shows the phone conversation between Mr. Blaise and Misazila on the 14th of December. During the conversation, Mr. Blaise does not show any surprise about the mass arrests. Mr. Blaise was expecting the attack and asking for confirmation of it happening. This further solidifies the existence of the plan and policy as well as his involvement in it. Mr. Blaise's mens rea will be further discussed by my co-counsel. But according to the elements of crimes, the overall mens rea for the crime of enslavement is present if the perpetrator knew that their conduct was part of the said attack. Individuals do not need to know all characteristics or details of the attack or the policy. According to the decision on confirmation of charges decision of the Katanga case, if individual perpetrators have a knowledge of the attack and are aware that their acts were part of these attacks, they have the mens rea needed for this crime. We have detailed the large-scale nature of the attacks and policy required to execute them. These attacks were even publicized with press releases. To think that the individual perpetrators were not aware of these attacks and that they were not aware that their acts were part of these attacks would be completely unreasonable. This court has subject matter jurisdiction over this case. I will move on to the second issue of admissibility. The case is admissible before this court, and Mr. Blaise's amnesty does not change that fact. Our first claim is that it was not granted in the manner envisaged under Articles 17 and 20 of the statute. For a case to be inadmissible, there must have been a completed trial before a court, and that court must have given a judgment on the merits of the case. This was confirmed by the admissibility and abuse of process challenges decision of the Bemba case. Mr. Blaise's amnesty was given in accordance with Law Number 14. Its Article 3 reads as judicial control. The individual shall then appear before a judge who will assess whether the preconditions have been met and decide whether an amnesty shall be granted. The judge did not review the merits, let alone give a verdict on the merits. They only reviewed if Mr. Blaise has made a public apology as described in the rest of the article. Even the name of the process is called judicial control. There's no mention of trial or court, and the mere presence of a judge does not equate to the existence of either. This amnesty does not constitute a court decision. But in the event this court finds otherwise, we claim that the case against Mr. Blaise is admissible under Article 17(1)(c), as the proceedings granting the amnesty fall under the exceptions provided in Article 23, because the state of Fire Republic was unwilling to genuinely prosecute him. First, any application of Law Number 14 was for the purpose of shielding Mr. Blaise from criminal responsibility, as stated in Article 23A. Recent jurisprudence explicitly deems domestic amnesties as invalid when they are granted for acts amounting to crimes within the jurisdiction of this court. The IACHR found in its Barrios Altos versus Peru case that amnesty was considered invalid because it excludes criminal responsibility and undermines the state's duty to prosecute and punish crimes. Mr. Blaise's amnesty was given for the crime of enslavement, a crime within the jurisdiction of this court. And he sought this amnesty as protection from criminal prosecution after the international community's outrage and condemnation of him as the mastermind behind the attacks. This amnesty is invalid, and since Mr. Blaise solely sought it because he feared prosecution by the ICC, its application to him specifically is shielding him from potential criminal prosecution by this court. Alternatively to shielding, the proceedings were not conducted in accordance with Article 23b. First, the proceedings were not done independently or impartially in accordance with the norms of due process recognized by international law. Under law number 14, one of the preconditions for amnesty is a public apology conducted by the BNS, the direct perpetrators of the acts. The only other precondition is applicable to a single party, Aang. These two conditions cannot be considered as impartial or independent, since an already liable party is involved in the apology process, and the parties receiving the amnesty are not subject to equitable conditions. Second, the proceedings were done in a manner which was inconsistent with an intent to bring Mr. Blaze to justice. Mr. Blaze made his apology and was granted the amnesty a mere 4 days later. Your Honors, reasonable people such as ourselves would be suspicious of calling such an expedient trial as viable or genuine, especially when it concerns this grave a matter. Besides, there's absolutely no indication that the victims accepted the apology. Every bit of information we have, from the initial human rights violations to victims refusing to give statements on the situation and the dubious nature of the amnesty law and its application, directs us to the reasonable conclusion that there was a bias against Earth Bowers and a bias in favor of the president. Fire Republic was unwilling to genuinely prosecute Mr. Blaze, and the amnesty was part of the charade. Mr. Blaze, in response to international outrage, granted himself a haphazard amnesty to escape criminal justice before this court. Accepting this amnesty would declare to all those with the power and intent to commit such atrocities that they would be able to do so without any consequences. It would defeat our sole purpose, which is ending impunity for atrocities so that we may prevent them from happening in the future. We must fulfill our purpose and responsibility to the international community as well as any current and potential victims. We plead that this court finds the case against Mr. Blaze as admissible. I will now yield the floor to my co-counsel. Thank you.
Madam President, Your Honors, may it please the court. My name is Özge Karsu, and on behalf of the OTP, I will plead on the third and fourth issues, which are about the interests of justice and Mr. Blaze's criminal responsibility under Article 28b of the Rome Statute. I will speak for 12 minutes. Now, the case against Mr. Blaze serves the interests of justice, and it will not destabilize the peace process. Under Articles 53.1c and 53.2c of the Rome Statute, the OTP has the discretion to terminate an investigation or prosecution on the basis that it would not serve the interests of justice. As also confirmed by the court in the decisions on situations in Georgia and Burundi, the OTP is not required to demonstrate that initiating an investigation or prosecution is in the interests of justice. Serving the interests of justice is not a positive requirement. Therefore, the OTP does not have to prove that the present case serves it. But if this court decides to depart from its previous jurisprudence, the present case indeed serves the interests of justice. Interests of justice should be defined as criminal justice. This interpretation is consistent with the object and purpose of the Rome Statute. Terminating an investigation or prosecution on this basis is exceptional, and there is a presumption in favor of investigation and prosecution. The OTP makes such a decision, taking into account all circumstances, including the gravity of the crime, the interests of the victims, and the particular circumstances of the accused. In the present case against Mr. Blaze, the OTP has found no reasons to terminate the investigation or prosecution. On the contrary, the gravity of this case and high-level authority of Mr. Blaze indicate that the case serves interests of justice. Further, it is not sufficient to argue that the amnesty law provided justice. The amnesty terminated all ongoing investigations and prosecutions, and revoked criminal sanctions. It is the quintessential indicator of Fire Republic's unwillingness to prosecute its president, Mr. Blaise. The amnesty did not provide justice. Rather, it was used as a tool to escape from it. Justice should never be sacrificed by granting amnesty in ending conflicts. Hence, the OTP submits that the case against Mr. Blaise serves the interests of justice, and a lawful prosecution against the defendant would never harm a genuine peace process. And if the defense argues otherwise, they should first provide relevant evidence and have a reasoning. Otherwise, this would remain as a mere threat to this court. I will now move with the fourth issue. Mr. Blaise, the president of the Fire Republic, is criminally responsible for crimes against humanity of enslavement under Article 28b of the Rome Statute. Mr. Blaise's criminal responsibility will be examined in three constitutive parts of superior responsibility. Accordingly, there are reasonable grounds to believe that, first, Mr. Blaise had effective authority and control over the BNS forces. Second, Mr. Blaise knew or consciously disregarded information which clearly stated that the subordinates were committing the crime. And third, Mr. Blaise failed to take the necessary and reasonable measures to prevent or repress the crime. I will now move with the first claim. Non-military superiors may be found responsible for crimes committed by their subordinates if the superior has effective authority and control. As stated by this court in the Bemba case, effective authority requires the material ability to prevent or repress the crime, or the ability to submit the matter to competent authorities. The court also noted that this determination is a matter of evidence rather than substantive law. Further, in the Bemba case, the trial chamber determined several criteria to indicate the existence of control on the basis of evidence. Accordingly, the power of the superior to issue orders, the capacity to transmit reports to competent authorities, and the position of the accused are indicators of effective control. In the present case, there was a hierarchical relationship between Mr. Blaise and the BNS. Mr. Blaise established the BNS and ordered Ms. Azila, Minister of Interior of Fire Republic and the leader of BNS, to monitor the situation in Black Mount and take the necessary measures. There was also a direct reporting system between Mr. Blaise and Ms. Azila. According to the second article of the executive order, every 6 months, Mr. Blaise received direct reports. As shown in clarification 2, Ms. Azila submitted all her reports to the president as requested by the order. Further, according to the phone conversation on 14th December 2018, as shown in Exhibit 1, Ms. Azila confirmed that she will send her first report before the end of the year. Considering that this was only 3 months after the executive order, that report was an extra one. This makes the direct reporting system between Mr. Blaise and Ms. Azila even stronger than it was set out in the executive order. Further, Mr. Blaise was able to give orders to BNS. As shown in Exhibit 1, Mr. Blaise ordered the release of some of the detainees and transfer of 10,000 others. Even the peace negotiations with Aung started after Mr. Blaise's order to BNS. Taking and implementing orders within such a reporting system demonstrates Mr. Blaise's effective authority and control. I will now move with the second claim.
Before you continue, I've got a couple of questions. In respect to Mr. Blaise, sort of effective control, the way I read the facts is slightly different. The BNS was an arm of government. The government or parliament likely created it. It wasn't created by Mr. Blaise. the Minister of Interior was not appointed, as I read the facts, by Mr. Blay. I agree he signed an executive order requesting the government to monitor the situation, that being the BNS, and to reestablish peace in Black Mountain. Azila was tasked with monitoring the situation, which was a request, not an order per se, and of using the necessary means to end the potential threats to national security. Again, the executive orders does not talk about establishing camps, taking prisoners, enslaving them. And then the request again is for the Minister of Interior to report directly to the President on the situation, or probably on the enforcement of the executive order. All of the actions were taken by Mrs. Zilla under the general request and order. How does that show that he either directed the crime, was aware of a crime, or had direct responsibility for the BNS and Mrs. Zilla and the people who committed the crime? She had the direct authority.
Thank you, Your Honors. As confirmed in the court in the Bemba case, the suspect's knowledge can be obtained by direct or circumstantial evidence. In the Bemba case, the court further stated that there are several factors which indicate the existence of knowledge. These factors, which were taken from relevant jurisprudence of the ad hoc tribunals, include the widespread occurrence of the acts, the means of available communication, the organized structure with an established reporting system, the scope and nature of the superior's position and responsibility in the hierarchical structure. First, as shown by my co-counsel, the attack was widespread and systematic, and there was a policy to commit the attack. Second, Mr. Blaze was the president of the Fire Republic. He was the one who had the highest degree of responsibilities. And also, as you confirmed, as per paragraph 7 of the case facts, Mr. Blaze signed an anti-executive order and established the BNS. Accordingly, he was able to give...
He didn't establish the BNS. The BNS was in existence. He tasked the BNS.
Yes, Your Honors. As per the first article of the executive order, Mr. Blaze tasked the BNS and Ms. Azila, who was the Minister of Interior of Fire Republic, to monitor the situation in Black Mountain and take the necessary measures. This demonstrates the hierarchical relationship between Mr. Blaze and the BNS forces. And further, as demonstrated before, as per Exhibit 1, there was as per Exhibit 1 and the second article of the executive order, there was a direct reporting system between Mr. Blaze and Ms. Azila. And in addition to these regular reports, the phone conversation in Exhibit 1 demonstrates that there was constant communication between them. These factors are strongly...
There was one conversation.
Yes, Your Honors.
You have no other evidence other than that single call. And your case is based entirely on circumstantial evidence, correct? You have no direct evidence of him having effective control. We have one phone call and one confirmation from his office that goods are going to be sent to the education centers. You don't have any direct evidence that Mr. Blay knew what was going on in Center Rig. Is that right?
Yes, Your Honors. We are basing our arguments on circumstantial evidence. And excuse me, Your Honors, I know my time is up, but can I continue to answer your question?
You'll Please continue, but make it brief. I'm sorry to have taken up so much time.
Thank you, Your Honors. We are basing our claims on circumstantial evidence. But cumulative effect of circumstantial evidences have a decisive role. The nature of the crimes within jurisdiction of this court is such that it is very often difficult or even impossible to establish the matter charged by direct evidence, such as testimonies. That's the reason
we understand that, but I just want to get to what are you asking us to weigh at the end of the process as the circumstantial evidence on which we can find Mr. Blay responsible in this case?
Thank you, Your Honors. At the present stage, it is sufficient to prove that there is reasonable grounds. There is reasonable grounds to believe that Mr. Blay is responsible under Article 28b of the Rome Statute, and the reasonable grounds can be defined as a reasonable conclusion alongside the others, which shows that Mr. Blay can be criminally responsible.
I understand you had to address questions, but we need to be on time, so please finish your sentence.
Thank you, Your Honors. For the foregoing reasons, the OTP respectfully urges this court to find that the court has jurisdiction. The case is admissible and serves the interests of justice. And there are reasonable grounds to believe that Mr. Blay is criminally responsible under 28b of the Rome Statute. The ones who are responsible for the labor camps must not go unpunished.
I'm sorry, Counselor, but I think the time is over. So to be fair to all participants, we have to stop here then. Thank you very much.
Thank you, Your Honors.
And now I'd like to give the floor to the defense to present your submission.
Thank you very much, Madam President. Madam President, Your Honors, good afternoon again, and may it please the court. In response to the prosecution, the defense will make 4 submissions. Firstly, I will demonstrate that this court does not have material jurisdiction over this case. Secondly, that this case is inadmissible before this court. Thirdly, that this case is not in the interest of justice. And fourthly, that Lord Blay is not individually criminally responsible under Article 28b. Regarding the first claim, the prosecution argued that the right of ownership is not required under enslavement, and that the Earth Power population was enslaved within these centers. Within this claim, I will first submit the requirements of the enslavement and mention and submit why forced labor has not been fulfilled. Regarding the elements of enslavement, Your Honors, Rome Statute, Article 7, Paragraph 2, Subparagraph A, and the elements of crimes are clear. There is a requirement for the exercise of the right of ownership over individuals. This was also confirmed in Kunaraj Trial Chamber Judgment, Paragraph 542, where the trial chamber there stated that the detention in and of itself cannot amount to enslavement. There must be a more severe act, and that act can be forced labor or other ways of exercising right of ownership, as per stated in the elements of crimes, such as bartering, purchasing, or lending individuals. And in our case, we require such an act of forced labor to prove that enslavement has taken place. In regards to forced labor, according to the Forced Labor Convention of 1930, forced labor requires a lack of consent or a consent rendered irrelevant by a menace of penalty. And in our case, the detainees had consent to participate in these education programs for mechanics and trades, and their consent was not rendered irrelevant. In regards to the fact that they had consent, if I may direct your attention to paragraph 9 of the case fact, it is clear that a mechanics and trades program was established by the Ministry of Interior to bring the earth powers back into the community. This is also corroborated by Exhibit 2, which authorizes the sending of materials such as steel, an engine, rubber, and glass to the center rig. These are materials that are to be used within the education program. And if the detainees did not wish to participate in this education program, these individuals were kept with other detainees. There was no menace of penalty. And regarding the fact that individuals did not have their consent rendered irrelevant, the prosecution claimed that based on the statements of Haru Rock, one individual allegedly within center rig, as we can see in paragraphs 11 and 12, there has been a menace of penalty, namely lack of food or water if the detainees were refused to work. Your Honors, according to Kurnoyelach, paragraph 195 of the Appeals Chamber judgment, the statements of an individual detainee without any objective evidence corroborating it cannot be used to establish forced labor or enslavement. And here, the prosecution is solely relying on the statements of one individual to an NGO. Therefore, Your Honors, there is no reasonable basis to believe that the crime against humanity of enslavement has taken place, and therefore, this court does not have material jurisdiction over this crime or alleged crime. Moving on to the second submission, which is the submission of admissibility, the prosecution claimed that, firstly, that the trial did not take place because it wasn't on the merits of the case. Secondly, that under Article 20, paragraph 3, subparagraph A, the amnesty was to shield the accused, and according to 20, paragraph 3, subparagraph B, there were essentially proceedings that were not serving justice. I will now address them in the reverse order. Your Honors, the point of Article 20, paragraph 3, subparagraph B, under the wordings of the Appeals Chamber in Al-Sanusi judgment, paragraph 422, is to make sure to deter sham proceedings. Your Honors, if I may direct your attention to paragraph 17, the amnesty itself is not a sham proceeding. Essentially, the AANG and the Far Republic government sat down on a negotiating table and decided to follow justice in another way. This does not make the whole process of amnesty a sham proceeding. Otherwise, this would also be against the intentions of the drafters of the Rome Statute, who made a proposal to include amnesties, include a ban on amnesties, but this proposal was rejected. So amnesties cannot be considered to be against Article 20, paragraph 3, subparagraph B. Moving on to subparagraph A of paragraph 3, Your Honors, the amnesties themselves do not carry the intention to shield accused. Amnesties carry the intention to ensure a transitional justice and reconciliation process within a country. This was also confirmed by the preparatory works of the drafters of the Rome Statute, who stated that under the complementarity regime, legitimate offers of amnesty shall be considered under complementarity. And in addition, the prosecution cited the Barrios Altos versus Peru case in arguing that the amnesties shield the perpetrators. Similar argument was made in the case against Gaddafi. The pretrial chamber in Gaddafi stated that there's a tendency to not allow, to find inapplicable amnesties before international courts. And this followed from the fact that countries had the obligation to, the supposed obligation to prosecute, and that amnesties shield the accused from crime, from prosecution. However,
Sorry, I have one question. So, shouldn't we argue here that national proceedings lacked sufficient independence and impartiality? We have to take into account the Lord places the president of Fire Republic, that no measures were taken to avoid any conflict of interests, that the public apology was done before DPNS, which is under lower places authority. So what would you argue here?
Your Honor, our submission on that will be that this amnesty is under judicial review by a proceeding conducted by a Fire Republic judge. And there is no case facts whatsoever regarding the impartiality or partiality of the Fire Republic judge. Therefore, we cannot state that this falls under Article 20, paragraph 3, subparagraph B of the Rome Statute, since there is already a judicial review set up as a mechanism, as part of the law on the amnesty, law number 14. So, Your Honors, to conclude on the issue of the shielding of the accused, this argument was made by the pretrial chamber on Gaddafi, which subsequently was rejected by the appeals chamber in its decision on this case. The appeals chamber confirmed that there was a tendency within international law to make amnesties inapplicable, but they also stated that this rule was not settled yet. Therefore, it is not law. There is no laws regarding the inapplicability of amnesties, and the Rome Statute drafters certainly did not intend this provision to ban amnesties, as the drafters themselves considered this under the complementarity regime.
Counsel, could you please explain the difference between the question of the legality of amnesty under international law and the question of the opposability of amnesty to International Criminal Court?
Your Honor, could you please rephrase the question?
I'm afraid I cannot, but
Very
yeah.
well. My apologies, Your Honor. Then I will try to understand it. I'll try to reply as the way I understand it. Your Honor, Madam President, the court in the case on Gaddafi basically stated that there was a tendency by the international courts, such as the Court of Human Rights of the Europeans and the Inter-American Court of Human Rights, to find amnesties inapplicable before international courts under international law. However, these are courts of human rights. The International Criminal Court is indeed a criminal court, and it is bound by the Rome Statute. And if, according to Article 21(1)b, it also applies international law in the second place. And in international law, there is no ban on amnesties, and therefore the court cannot apply such a ban. And regarding the argument that the manner envisaged in Article 17(1)c was to make sure that a judgment on the merits was rendered, the prosecution argued that in the Bemba case, it was clearly stated that a full-on trial was required with presumably a conviction or acquittal. In the case of Bemba, there was a judgment that was not final. In the Bemba case, the national court decided that there was not enough evidence for the proceedings to continue, but the prosecution could come again and try one more time. The matter was not settled. This was similar in the case of Gaddafi in the pretrial chamber, where they clearly emphasized the word final repeatedly. Your Honors, following the complementarity regime principle and the nebis in idem principle, what is required is a final judgment on the matter, or in other words, for the matter to be settled. In our case, the matter has been finally settled by the Fire Republic courts. It cannot come before a judge within the Fire Republic again, and therefore the rule against double jeopardy has been engaged. Therefore, this case is inadmissible before the International Criminal Court. Moving on to the interest of justice. Your Honors, the prosecution claimed that the prosecutor does not have to demonstrate that the case is not in the interest of justice or would serve the interest of justice. However, Rome Statute Article 53(2)(c) clearly instructs the prosecutor to not continue with an investigation or prosecution if a case would not be in the interest of justice. Therefore, the prosecution has to assess whether a case would be in the interest of justice nonetheless. And in our case, the peace process makes this interest of justice consideration in favor of foregoing a prosecution in our specific case. Your Honors, in this claim, I will first argue why the peace process shall be considered under the interest of justice considerations, and secondly, why this peace has been or is being jeopardized by this prosecution. Regarding how peace falls within the interest of justice, Your Honors, the OTP itself on its policy paper on interest of justice, page 8, has stated that security and crime prevention within the region is within the considerations of interest of justice, and they stated this under the heading of peace processes. Furthermore, it has been recognized that by the United Nations General Assembly that the peoples have a right to peace. And it has been the general aim of the international community to ensure peace. And therefore, peace clearly falls under the interest of justice considerations. And regarding how peace is jeopardized in our case, there has been years of unrest within Black Mound. This unrest led to violence that spread to the neighboring, almost spread to neighboring regions. And finally, the Fire Republic government with the AANG decided to put an end to the conflict. And as we see on paragraph 17, a peace agreement was reached, and it was built upon a transitional justice mechanism in the name of a Truth and Reconciliation Commission, which was coupled by an amnesty.
Sorry, one question. Should we take here into account victims' rights? Can you explain to me, please, if the rights of the victims are going to be satisfied with these national proceedings? What about the reparation?
Your Honor, of course, the rights of victims shall be considered under the interest of justice as well. But in our case, firstly, there is no information regarding the victims wanting something, a prosecution rather than an amnesty and the Truth and Reconciliation Commission. And secondly, according to the the Secretary General's report of 2004 on the rule of law and transitional justice, national jurisdictions may choose how they wish to proceed with justice. Justice does not have to happen within the courtrooms. In our case, the AANG and the Fire Republic, together as the parties of the conflict, reached this agreement. This means that the rights of the victims have also been taken into consideration. And as we see in clarifications to the case fact, clarification 5, that both the AANG and the Fire Republic government has representatives within this Truth and Reconciliation Commission. And therefore, this should also be taken into account. But now, this prosecution, Your Honors, is undermining this very structure which the peace was built upon. In addition, prosecuting Lord Blaze antagonizes the government of the Fire Republic as a party of the conflict, and in turn makes the peace fall into jeopardy. To conclude this claim, since this prosecution is undermining the very foundation which the peace was built upon, and the fact that it is antagonizing one of the parties who, according to paragraph 17, was the party to call to peace, this case does not serve the interest of justice. Moving on to the individual criminal responsibility of Lord Blaze. Lord Blaze cannot be held criminally responsible because he did not have effective control over the perpetrators, and also he did not have knowledge that or did not consciously disregard information which clearly indicated that the crime against humanity of enslavement was taking place. In regards to effective control, I would like to first make a clarification. According to the paragraph 12 of the case facts, Mr. Harurak alleges that enslavement has been taking place in Center Rig, and he ties the BNS to the events. There are no submissions as to the criminal responsibility of Ms. Ursa Özila, or no evidence to show that Ms. Ursa Özila herself is criminally culpable. Therefore, we should restrict our review to the BNS agents in Center Rig regarding effective control. Otherwise, this would also fall against the findings of the Orich Appeals Chamber in paragraph 48, which stated that if there were no submissions regarding the identified criminal culpable and there was no evidence as to their role within the crime, then superior responsibility cannot be found. Now, turning to the effective control of Mr. Lord Blaze over the BNS agents, we submit that Lord Blaze did not have effective control over them. The effective control is indeed defined, as the prosecution said, in Bemba Trial Chamber Judgment paragraph 188, as the material ability to prevent, repress, or punish crimes. However, the appeals chamber, while they endorsed this approach, they fell into disagreements. The majority of the judges, the 3 judges, appendixed two different separate opinions stating as to when this material ability is reached. We submit that Lord Blaze cannot have criminal responsibility or effective control over the BNS agents within Center Rig, because he cannot effectively manage or monitor these individuals within Center Rig. This view is followed also by Judges Morrison and Van den Weingart, who stated that effective control cannot be found for superiors of such high level because they will not be able to effectively manage or control or monitor individuals on the ground. That is the work of those who are supervising them immediately, who are the immediate superiors. The prosecution argued that Lord Blaze had control over the BNS, and we would agree with that to a certain extent, as he managed to give orders that were general enough to give general orders in essence. However, in the opinion of Judge Osuyi in Bemba Appeals, it is stated in paragraph 259 that the general orders of such case, such as an order to retreat or to stop the whole operations, does not provide an evidence for effective control. Therefore, we submit that Lord Blaze did not have effective control over the BNS agents. In addition, Lord Blaze did not have knowledge that these crimes have been taking place. If I may direct your attention again to the phone call, the Exhibit 1, we see that within this phone call, there is no mention of any criminality. There is only a request by Ursa Özila for more supplies to Center Rig, which, as we have seen in Exhibit 2 before, Lord Blaze obliges by sending materials for an education center. That is what Lord Blaze has knowledge about, an education center for mechanics and trade for earthbowers. The prosecution has also argued that Lord Blaze knew of the crimes due to the reporting structure set up between Ursa Özila and Lord Blaze. Your Honors, according to clarifications to the case fact number 2, Ursa Özila sent all her reports based on this reporting structure and in accordance with it. This means that in September, this reporting period of 6 months started and it ended within in March. Later on, in 1 month, the conflict ended. So Ms. Ursa Özila had the chance to submit only one report to Lord Blaze. And the prosecution is relying on this report without telling or without making any submissions or providing any evidence as to its contents. Your Honors, the prosecution is effectively asking this chamber to make 4 assumptions based on these reports, which they cannot show any contents of. Firstly, that Mr. Haru Rock told the truth according to paragraph 12, and there was indeed the crime against humanity of enslavement taking place. Secondly, that Ursa Ezila knew that these crimes were taking place or even conducting these crimes herself. Thirdly, that Ms. Ursa Ezila indicated these crimes within her report. And fourthly, as required by Article 28b(1), this information clearly indicated that crimes against humanity of enslavement were taking place. Your Honors, there is no reasonable grounds to believe that Lord Blaze was criminally responsible, as there are no reasonable grounds to believe that he had effective control over the BNS agents, or that he had information that crimes within the jurisdiction of the court or the crime against humanity of enslavement was taking place. To conclude, this court does not have material jurisdiction over this case because the crime against humanity of enslavement cannot be established due to the lack of the proof on forced labor. Secondly, this case is inadmissible due to the fact that it has been finally settled. Thirdly, this case does not serve the interest of justice because the peace process is being undermined by this prosecution. And fourthly, Lord Blaze cannot be held individually criminally responsible. If I may be of no further assistance, this concludes the submissions of the defense on the main pleadings. Thank you very much.
Thank you very much. Now I'd like to give the floor again to the prosecution for a 5-minute rebuttal.
Thank you, Madam President. Your Honors, may it please the court. In response to the arguments established by the defense counsel, the OTP will raise the following points. First, the defense has argued that the evidentiary standard is reasonable basis. That is the standard in the authorization of investigation state. This is the next stage, where the evidentiary standard is reasonable grounds, as confirmed by the PTC decision in the Republic of Kenya. At this stage, it is sufficient to prove that there's reasonable conclusion alongside others which can be supported on the basis of the evidence and information available. Regarding the first claim on jurisdiction, we would like to invite the Honorable President and Your Honors to look at crimes, the elements of crimes, Article 7(1)(c), footnote 11, where it is specifically said that right of ownership and similar deprivations of liberty. There, it goes on to say that these can include exacting forced labor or otherwise reducing a person. And they use Supplementary Convention of Abolition of Slavery as support. This is also confirmed by the Kunaraj case in the appeals chamber in paragraph 117, that this is in fact the customary interpretation of slavery. It includes contemporary forms of slavery. Exhibit 2 does not corroborate the voluntary nature of the so-called educational program. The defense also is basing their argument on voluntarity solely on Ms. Azila's press statement, which is completely unreliable since she is a direct perpetrator of the act. Mr. Rock's interview was at least made with an NGO. Mr. Rock is a very brave man, willing to recount the atrocities he has been subject to in hopes of exposing Fire Republic. Regarding the second claim on admissibility, if the counsel for prosecution had read the Al-Sanusi decision in its entirety, he would have understood that the sham proceedings referred to in it was elaborated to arise that there are obvious and unexplained deficiency in the investigation and prosecution, and the perpetrators go unpunished. Therefore, the critical question before us is, did Lord Blaze go unpunished? And he did. Additionally, regarding the invalidity of the amnesty, the Gaddafi decision said that that the council has referred to, did elaborate that there is an established position that amnesties granted against crimes under the jurisdiction of this court are invalid. Therefore, the jurisprudence in this matter is not just under human rights international law, but it has been established under the scope of this specific court. Your Honor, the defense has wonderful rhetoric, but that is all it is. It is rhetoric. The defense counsel mentions that peace and security as the object and purpose of the Rome Statute. However, the primary object and purpose of this statute is ending impunity for international crimes, because we want to deter future perpetrators from committing these atrocities again. The years of conflict in Black Mount, as stated by the defense, have been long and grueling, but they were initiated by Mr. Blaze when he decided to take away the human rights of the Earthbound population. Now, instead of giving us concrete evidence that the peace process will be disrupted, the defense is insisting on continuing their threat. If the peace process is so fragile that it can be disrupted by a legal prosecution, was it really genuine to begin with? And was Mr. Blaze's following amnesty genuine? Either. It was not. Regarding the fourth claim on superior responsibility of Mr. Blaze, the Fire Republic did not provide us with any of the reports that Ms. Azila gave to Mr. Blaze. This shows their unwillingness to provide evidence that might exonerate Mr. Blaze according to the defense. That makes the OTP suspicious. Also, Mr. Blaze was in a position of effective authority and control. There was a hierarchical relationship and a direct reporting system between the two of them, and there were at least 3 reports between the two. Further, even though the superior did not personally affect the commission of the crime, he could still be liable only because of his culpable omission, such as the failure to repress or submit. The PTC in the Bemba case also argued that the causality element is required only in terms of a breach of duty before the crime, which is the failure to prevent. Your Honors, for a state to move on, the truth must come out. The TRC did not provide the truth. But the truth has yet to come out, which is why the prosecution and this court must work to unveil it so that the people of Fire Republic may move forward. You can't have a future unless you can clean up your past. Thank you, Your Honors.
Okay, we have to stop. Counsel for the defense, would you like to take the opportunity for a 5-minute rebuttal?
Yes, Madam President, if I may.
Yeah,
Thank you very much. Madam President, Your Honors, good afternoon again, and may it please the court. In response to the prosecution, I will be making 5 submissions, But firstly, I would like to address that the prosecution has stated that the defense failed to provide evidence in regards to the exoneration of Lord Blaze. Your Honors, it is a clear rule of international criminal law and criminal law, and it is envisaged in Rome Statute Article 66 that the defense does not have to provide evidence to show their innocence. It is the prosecution, the burden of the proof is on prosecution to prove that the crimes within the jurisdiction of the court has happened, and it is not the job of the defense to provide evidence to show that it wasn't. And within this, the prosecution stated at the start of their rebuttal that the case at hand requires reasonable grounds to believe in our stage of proceedings. And that is correct. I would like to thank the counsel of the prosecution for correcting me. However, on Kenya, Article 15 decision, paragraph 33, it has been suggested and stated that the reasonable grounds threshold is higher than the reasonable basis threshold. And the reasonable basis threshold can be met according to Article 30 if the evidence and if the assumptions or if the inferences are fair and sensible. And in our case, relying on the sole testimony of one individual, while there were alleged 100,000 victims, is not fair and sensible when a person is being indicted and brought before an international court. And regarding the prosecution's submission, on forced labor and the fact that enslavement does not require the exercise of ownership, Your Honors, it does, because forced labor is, in a sense, the usage of the right of ownership over individuals. In the Ongwen case, enslavement was found through forced labor when the women or the supposed wives of Ongwen and his lieutenants were used as property for crimes such as simply as doing chores, but also other heinous crimes where they were made so-called wives. Furthermore, in Kunaraj, women were enslaved as they were treated as property. They were rented out, they were sold, and they were bought or purchased. The crime against humanity of enslavement requires the right of ownership to be exercised or for it to be comparable to it. And in our case, forced labor is not established due to the lack of evidence the prosecution has. Regarding the allegation that amnesty is not genuine, Your Honors, on paragraph 17, we see that amnesty has been brought forward by both the ANG and the Fire Republic. This was not a case where Lord Blaze wanted to keep himself criminally responsible, so he built this amnesty mechanism. No, this was a case of a reconciliation between the parties and the peoples of the Fire Republic, which the court shall respect under the complementarity regime. And finally, Your Honors, the prosecution has stated that the original intent of the Rome Statute is ending impunity, and we agree with this. But in our case, the justice is being reached by this Truth and Reconciliation Commission and the domestic measures of the Fire Republic with all its constituents. To conclude, Your Honors, this case shall not be in the interest of justice, shall not be admissible, and this case is not within the jurisdiction of the court. Thank you very much.
Thank you very much. This concludes the submission of the parties. The chamber will now retire for deliberation and announce the decision in due course. Thank you.
I will now send the judges into the deliberation room and the team members into separate breakout sessions.
Madam Bench, could you please kick P1 out of the meeting because my computer crashed? Thank you.
Welcome again, everyone. I'd like to let you know that according to the rules for the Nuremberg Moot Court 2021, deliberations were made to assess each of the teams participating based on the following criteria: knowledge and understanding of the facts and legal issues of the case, use and understanding of the law and international jurisprudence, reasoning, and overall presentation. So now I would like to give floor to each judges for a brief comment to all of you. So Judge Kremer, why don't you start?
Shouldn't we announce who the winner is?
I think I will announce the winning party at the end. And
At the end,
before we
okay.
announce the winning party, we could give them comment.
Okay, fine. You both teams were very good. I thought you were very organized. You stuck to your script pretty well. For the team that's moving forward, my advice is don't be so scripted, because more questions are going to be flying, and you have to be able to decide how much detail you're going to go into and answering all of the questions, but you have to know where you're going, and it can't be pre-scripted. You have to say, okay, this point is part of my answer, where I was getting to, and you incorporate it into your answer. So you have to be flexible and don't get distracted by questions coming at you. I thought both teams did a good job of using the facts to explain why the applicable law applied. There were occasions where you discussed the law and gave a little bit of facts, but the explanation sort of as to why you win wasn't as persuasive as it needed to be. So you should be basically saying, here's what we say the facts are about Lord Blay and why he had effective control, and this effective control that we've just set out is supported by the legal interpretation of what is required for superior. You can, so you have to decide, do you want to use the facts first, or do you want to use the law first? My advice, after having spent 10 years at the ICTY arguing appeals, facts win cases, the law doesn't. So if you're going to emphasize moving forward, emphasize by using the facts well. Anyway, those are my comments.
And I would like to give floor to Judge Silva for her brief comment.
Thank you. No, I just want to say congratulations to both teams. You were both great. You were very structured, easy to follow. You addressed the points. As Judge Kremer said, I think you have to maybe, be a little flexible and learn to give room to improvisation. I think that's really important. But in general terms, you both did a great job, and you answered correctly our questions. And yeah, just congratulations.
Okay, I also truly would like to congratulate all of your excellent work. You both were very well prepared, and all judges will agree with that. And you both showed an outstanding knowledge of law, jurisprudence of international courts, and also your application of the law to the fact also showed your good knowledge. So, and your tone and your pace of the presentation were also very remarkable. So I truly would like to congratulate all of you, but at the same time, I need to announce the winning party. So the winning party is the counsel team for the defense. Congratulations. And now I think the court is closed.
Congratulations.
I will now stop the live stream.